We are live.
Okay, well, a couple of updates before we get into the procedures we're going to go over today. Danelle and Olga and I just were at a lengthy meeting with the city's employee relations department, and they and city attorney staff walked us through the process for approval of the operating procedures, and which includes the meet and confer process. I'll summarize it very briefly, but the process is, well, they would like us to have all of the procedures together as a packet. And the reason being is that the POA is likely to say that one procedure relates to another, which to a certain degree is true. So I told them I thought that we would have all the ones that were the core procedures that relate to our ability to do our job according to the ordinance by the end of June. And I think we actually, and by the end of June, I mean having us approve it, but also have the full commission approve it. In the discussion of the meeting, we came to a conclusion that that package, in addition to the ones we've already discussed, needs to include a one that I will refer to as a records policy, which will talk about the disclosure of records and PRAs and the retention of records and disposal of records. And a lot of that is determined by city policy. And so I've asked staff to work on drafting that. And I think Dwayne has drafted part of it. Maybe I don't remember exactly what he drafted, but if you can consult with him and do that. And then the second thing that they felt that we needed to include, we explained that we're not going to do the mediation program because that's a discretionary power, which we're not envisioning utilizing for at least a couple of years. But the review and evaluation of SDPD compliance with federal, state, and local reporting laws and requirements is actually a mandate of the charter and the implementation ordinance. And so they felt we needed to include that. I frankly don't know what that procedure would look like. The interim CPP transition planning committee asked the police department to provide us a list of all of their state, federal, and local reporting requirements. And they refused to give it to us. They said that that's not our job, but we'd be happy to answer any questions about them, but we're not going to provide you with a list of them, which I think is unacceptable. Anyway, so we need to figure out what we're going to do on that. And I think once we get a new police chief, we'll probably get more cooperation. But I think very quickly, I think my thinking is we need to have the department, provide us a list of all those requirements so that we can meet our requirements, our mandate as provided by law. Two, that they give us access to their submissions to those different agencies. And they indicated there's quite a few. We just learned recently about the pursuit policy and the forms that are required to be sent to the CHP, and that probably is one of dozens of there's the RIPA requirements. There's a lot of different requirements that they're required to submit. Anyway, we need to come up with the procedure for doing that. And we were thinking of postponing that because it's something that our performance auditor will be responsible for once that person is on board. And so we were hoping to delay that. And but as a result of today's meeting, they felt that we should include that policy, or that not that policy, that procedure in our packet. And so we'll need to think of how we want to do that, since it's a very vague mandate. But that just as a so that's Anything else regarding the meeting today that is important for the, oh, I didn't go back to the process. So the process is going to be that we will complete it. It then goes to the City Council's Public Service Committee. And Danelle is telling us that their agendas for the next several months are already pretty full with the police surveillance ordinance and other stuff. And so we're going to need to prevail on them to give us some expedited priority. After they approve it, then it goes to the full city council, and then the full city council directs the meet and confer staff, which is the people we met with today, to go through the meet and confer process. And they were reluctant to give us an estimate of how long that process will take. They said they'd have a better idea after they had their initial meeting. But the indication was that if we got it done in 6 months, that would be kind of record time. And so I took that to mean that we're probably looking at close to a year to get it approved. I'm just being realistic based upon how long everything else has taken. They also let us know that over the many years that they've been working with the POA, because these were the people, the staff who conducts the meet and confer with the POA or the people we talked with, they've only had 3 situations where there have been impasses, which means that the city and the POA could not come to an agreement. And so the city went ahead and imposed their policy on the POA. One of them was recently with the vaccine mandates. Mm-hmm. One of them, and remind me, now if I'm getting this wrong, may have been related to the pay cut or budget cut. I forget exactly what it was. Is that correct? I see Olga shaking her head. So it had to do with a
pay cut.
And the third one was the implementation ordinance for the CPP. And so they have done many meet and confers with the police department, and one of the 3 that has held up, that they've had an impasse on, has been related to the CPP. And frankly, I don't think that the implementation ordinance will be near as controversial as our procedures, because everything that was in the implementation ordinance was actually dictated by the city charter that was approved by the voters. And so we're getting into the nitty gritty of investigations and discipline and so forth. And so it'll be interesting to see what happens. And so, but anyway, that was the brief summary of the meeting today. Olga or Danelle, anything else that you wanted to add?
Great summary.
Okay, and then secondly,
well, before you move on, if I can ask a quick
go ahead. Yeah.
To what extent does the city council or the city itself have the authority to impose its will on the POA?
They have the ultimate authority, and so it's meet and confer, and so there are procedures that they have to go through, and if they don't go through those procedures, they can sue the city, and that can delay things. But ultimately, a meet and confer is to try to come to an agreement. Mm-hmm. But if they aren't able to come to an agreement, the city is able to impose their policy on the POA, provided they've gone through all the procedures. And so
if we come up with a set of procedures and the city really likes it a lot, they go into meet and confer, the POA can object all they want, and in the final analysis, the city can say, that's all right, thanks guys, we're going to do this anyway.
Well, they have to go through a good faith process, mm-hmm. and that's kind of defined by employment law. Mm-hmm. But I guess to answer your question with a yes or no answer, the answer is yes, that they ultimately, the city council can impose it.
I kind of thought something like that in the back of my mind, but every time I heard POA and meet and confer, it seemed like they get to say whatever they want when we have to do it. But that's good to know that there's a balance to that.
Yeah, and so we have it's not they have to agree. It's
mm-hmm.
we have to discuss it with them, and in good faith listen to their concerns. Mm-hmm. And by us, I mean the city. Listen to their concerns and make adjustments if appropriate. And so if there are adjustments, they go back to the city council and they have the city council sign off on those adjustments, and then they approve them. And the second thing I wanted to talk about was my homework assignment. And I ran into a little bit of difficulty, but I think I may have figured out what it was. The homework assignment was to check with Dwayne regarding the attestation, that he say it, statement at the end of the complaint form. And which we added at Dwayne's insistence during the tenure of the interim CPP, because of a court case which he claimed mandated it, and the SDPD did the same thing, and the sheriff's department did, which also had well, CLRB did, and I think the sheriff's department did too. Maybe Olga could correct me on that.
I don't think CLRB has it.
Okay. Anyway, so we Olga did some research and found that several agencies, both law enforcement agencies and oversight groups in California, did not do it. And so I asked him two questions. One was the law talks about it being required on complaint forms by law enforcement agencies, and we're not a law enforcement agency, so I wanted him to clarify whether we really have to have it or not. And he kind of told us we did previously, but we wanted to get clarification on that. And I guess that was what the question was. And so I sent the question and didn't get a response, which is unusual from Dwayne, because Dwayne usually responds right away. And even if he doesn't give a response right away, he tells me he's working on it. So I waited a week and didn't get a response. And so I sent a follow-up. In the meantime, between those two emails, Olga had emailed me regarding a bill currently pending in the state legislature, which would amend that attestation statement. We would amend that penal code section that requires it. It doesn't look like that's going to go anywhere, but it raised the question of whether we should include the actual language if the language is subject to change, because that then would require us to go back through the process every time the language changed. And so her suggestion, which I liked and Gloria liked, was that we simply refer to the penal code section that states that language, and say that the commission's forms will include any attestation form required by that, which something along the lines of which may be required by penal code section XXX. That does two things. A, it makes our document shorter, but it allows it, we don't have to change it every time the language changes. And by using the language which may be required, if it's determined later that we're not required to have it on ours, that we don't have to do it. If it's determined that we are required to have that verbatim language, then we will. And I said, I think I figured out why Dwayne didn't respond, and that was because the meeting we just came from, he was invited to the meeting, but he didn't know about the meeting. And it turns out that he seems to pay attention to his law office email and not the San Diego.gov email. And I was sending it to the San Diego.gov email. And I've run into the same problem with sending him links for cabinet meetings and so forth. So my guess is that he wasn't ignoring me, that he just was not monitoring his city email. Instead, was only looking at his personal email. Anyways, and so we can discuss how to proceed, but I can follow up with him after this meeting and have him clarify again. But if everybody else, and I guess that means you, Clovis, agree with the approach of saying that we, instead of including the language, say that we will Yeah. Yeah, so
Yeah,
maybe just,
that sounds good to me. I agree with that.
and how about the language that, and we also, as a result of the commission meeting last time, we also changed that, we added in that the complaint form will be available in multiple languages. So I'm kind of getting a little ahead of myself because giving that report, but our goal today is to finish the complaint procedure. And I think we can do that if we do what we just talked about doing, of saying that we're going to include that statement as required, or include in the attestation statement that may be required by that penal code section. And we can go through, and I forget what there were any other concerns, but we were almost done with the complaint procedure last time, and then we were going to look over the Pitchess motion and the subpoena procedures, which Dwayne drafted and is all legal procedures we don't really have any control over. But I'm going to give Clovis a chance to read through it, and hopefully he spent hours looking through that. And it is a tedious thing to read through, by the way. And then we can at the end maybe talk about, then our next policy after we finish these, and our plan would be to put these policies, the complaint policy, the subpoena policy, and the Pitchess motion / discovery policy on the agenda of the second CPP meeting in May. And then our next task is to look at the case review procedures. And the good news there is that I finished drafting those, and they are in the folder now. And so after this meeting, if you can, and I know that Olga's already looked through it because she's made comments, but Clovis probably is not, because he didn't know that I put them there.
Yeah, I must be looking at a different one that I was making notes on.
It's
This was required review of internal affairs investigation. No, okay. It's not the one I thought I was looking at. Okay, I'm looking at the wrong one. That's why.
It's
okay.
called updated proposed operating procedure for review of I investigations, V2, and I can link in the chat for you.
Okay.
Yeah, but it should be listed in the our committee folder, and if you sort them by date, it should pop up toward the front.
So I got complaint, old version, updated operating review of AI. Okay, I didn't see the updated one. I was looking at the other one. Okay.
Oh, then maybe you looked at the one that Olga looked at. I didn't know. Gloria made some changes, and I sent her a Word document, and she sent it back, and so I updated it, and then I discovered that Olga had already made some suggestions, and so I incorporated her suggestions and then re-uploaded it. So you may have been looking at it before I re-uploaded it.
Oh, okay.
But if you could, anyway, that we're not going to go through those tonight, but it's based on our prior procedures with the input from the commission that we talked about at the last, was it the last meeting or meeting before last? Anyway, we got the input from the commission on that, and some input from the cabinet, and I made those changes. And so now, if we can go back to the complaint procedure and see if there was any things that we had notes on that we needed to go over.
Yes, so we had this provision about that references this penal code that we left for discussion after consultation with Mr. Bennett, notwithstanding the foregoing, no complaint shall be investigated until a written complaint has been received by the commission, signed that the complainant attested pursuant to the requirements of Penal Code Section 148.6. So I proposed some other language instead of this one, and I have basically this kind of entire passage here is new. Specifically these 3 paragraphs, so that's kind of replacing this piece about the perjury statement as well. So let me know
Yeah,
your
can you-
thoughts on this one.
So it's the 3 paragraphs that are, you have
Mhm.
highlighted right there? Okay.
Yeah,
Yeah, give me just a minute because I didn't notice that, so. Okay, and where is that gonna, what's that going to replace?
it's going to replace this sentence. And then I'll scroll down to the other paragraph.
Okay,
Let me know when you're ready.
I am. Are you ready, Clovis?
Yes, I'm actually looking at it from the other
Okay,
document
perfect.
itself, so
And this sentence, and this section.
that whole section.
Mhm.
Okay.
Okay. So will we include a reference to a penal code section 148.6?
So I'm just wondering how to best do it, because I think the other agencies basically say something along the lines that like, be aware that any false complaint against a peace officer may be a person who files a false complaint against a peace officer may be guilty of misdemeanor, and that's kind of a one-liner. So here maybe we can make like it's this attestation form is kind of just included as part of the other forms. So if
Okay.
you feel like we need to put like a separate sentence about it, saying that the attestation form. I wonder if we should say may or will, shall reference, or in
Well, I think-
compliance with penal code section 140.6.
Well, we are going to inquire it. Yeah, I think it would be helpful because I'm sure if we don't reference the penal code when it goes to meet and confer, the POA is going to be all over that. So I think we ought to be proactive and include it. And where do you suggest that we'd put that, Olga? The reference to the penal code section?
Probably would be in the next sentence, the attestation form.
How
Will
about
be, go ahead.
how about the attestation form shall be in compliance with that penal code section? And then if it's determined we don't have to have it word for word in order to be in compliance, we wouldn't.
I'm fine with that.
Does that sound good?
Commissioner Honoré,
Yeah, no problem. But where is that sentence gonna go?
we're gonna type it right now.
Okay.
The attestation form shall be in compliance with, code. And I'll reread this again, and maybe if I see, I can put it in like in a separate, better section, can reorganize it. 148.6. Does that look okay? It's right here.
Yes,
Fine.
I agree.
So basically, we are removing a specific provision that any complaint needs to be filed in writing or through their online portal, or that we need a signed form. I think because it already mentions here, irrespective of the mode of filing of the complaint, commission staff will make every effort to obtain a signed attestation form from a complainant or impacted party. What are your thoughts on this one in particular? Because this suggests is that basically, and what the previous suggested is if the complainant calls over the phone and files a complaint over the phone, then they need to still go back and file a complaint online. And this is absolutely unnecessary as long as they attach proper attestation form to their complaint that's taken down by the staff member. I feel like that would satisfy the provision.
When
What-
isn't that how we currently do it?
Yeah, so I think this verbiage comes from CLERB's process, and I don't necessarily think that it's the most efficient process. So I think that's how we currently do it, and we should probably stick with it. It will just, it doesn't need to be that it needs to be reduced to a complaint filed through the online portal.
So if
Okay.
somebody calls in, how do we get the attestation form?
We just send it to them
Okay,
by
so they call
email
in-
or letter.
Okay, so they call in, we take all the information,
Mhm,
make some kind of file somewhere, and
mhm.
but I assume we inform them that we cannot move forward until we actually get the attestation form, or we
Yep,
can move
they
forward
are
without it, but they
informed
would
of
limit
that.
the capacity to investigate, or what?
Don't inform them about limited capacity to investigate because we're not investigating, but I think they are informed that they need to sign that form in order for it to be forwarded to internal affairs. The staff does their best effort to get that within 5 days. And then if they don't send it, but the complaint still appears like it may be within the SDPD jurisdiction, the staff still sends it to
Oh, okay.
SDPD and they'll make their own determination or their additional efforts to obtain that form.
Okay.
And I kind of spelled it out here, similar, basically the same process. It's pretty much spelled out in this procedure.
Gotcha. Okay, that's cool.
Okay, and were there any other issues?
So I guess the issues that are we comfortable removing this section and this sentence and replacing it with these 3 paragraphs?
Yes, I am.
Yes, ma'am.
Okay, perfect. So let me just make a note here so I don't forget. And I'll just do it right now in the suggestion mode. Delete.
Okay. What I can do is then after we get this cleaned up, and I'll wait to make, I'll coordinate with you, Olga, to make sure you've had a chance to get everything cleaned up. I can send it to Dwayne for him to look at, and I can explain why we didn't include the actual language. And we don't need to get into a debate of whether or not it's required or not, because we're saying that if it is required, then we would include that.
Mhm.
And we may want to get into another discussion later as to whether or not it is required, but it's not necessary to complete this operating procedure, is what I'm saying.
Okay. Okay, so the other thing, so we were kind of going through this notification to parties last section, but before we get to this section, I thought of adding another piece to this provision that we haven't discussed during the previous meetings is the communication between the department and the commission on the progress of the complaints. So I added this paragraph here so that it's all written, and then we kind of have this established agreement between the police department and the commission on this. And let me know what you think on this one.
Okay. Doesn't the ordinance state that if after X amount of time, I think it's 6 months, but I'm not quite sure,
Yeah.
that they will give us bi-weekly updates?
Yes, it does.
So I think
So
we should go
probably
ahead
should be
and,
added here. Right?
yes,
Right. Weekly updates. Sure.
and
But I
do
think,
you think it would be helpful and or necessary to include the municipal code section that requires that?
I think we can include that.
Yeah, I think it's always helpful
Yeah.
because then it keeps the POA from arguing about
Mhm.
that because it's already required by the law.
This is just, kind of, I came up with this, but I feel like that's important to have.
I agree. I think it's good to include.
The other piece I felt would be important is, I don't know what your thoughts on this is. The commission police department must establish an efficient and transparent joint system, allowing the two entities to mutually track complaints and matters referenced herein. Because I know that there have been efforts to come up with some sort of system. I don't know if they'll happen before this procedure goes through meet and confer or not, but
I
that was
love it.
kind of my thought process on this.
I
And
love
it was also included in an independent city auditor's report that should happen.
Oh, cool.
Okay. Yeah, I love that.
Okay, so we'll have something in writing on this one to begin with, hopefully. Okay, so do you all like this one? Can we keep it? And with the
Yes.
addition to the bi-weekly update after 6 months that I'll add after I go back to the ordinance and read the verbiage in it.
Yes, that's good.
Okay. And in looking at it, I think that the issue that Chief Neslight was concerned about was notifying us of the progress of internal investigations. But I think that the way this is worded, I think may have been the intent, is that this talks about them providing a monthly status update on all complaints forwarded to the department by the commission. And so those monthly updates don't apply to internal, and it probably is. That probably is okay because of the nature of internal complaints. And as the chief pointed out, sometimes there may only be a couple of people in the department that are aware that something's under investigation, if they are trying to verify that an officer, especially if it's something regarding illegal activity. So anyway, I'm just doing that as an aside, but I like the way this is worded because it avoids that issue. But I also want to make it clear that we will not probably know that a internal complaint is being investigated until they send us the investigation report.
So actually, this one includes internal investigations because I copied it from the ordinance.
So
it says the police department will also provide status complaint forwarded to the police department by the commission, and all police department investigations of alleged police misconduct, including internal investigations not resulting from a complaint, as well as officer involved shootings, deaths in custody, and deaths resulting from interactions with a police officer.
Okay.
If you feel like we should not reference the internal investigations.
No, I think we should, because that's what I read to the police chief, and he said it doesn't mean what it says, and yelled at me. And I mean, literally, I read it to him, and he goes, "I don't want to hear it." I go, "That's what the ordinance says." Well, our legal staff disagrees, and we're not going to debate it anymore. So I'm fine with putting in the wording of the ordinance because it's very difficult, and I would include the specific section. Because that's what I was looking at before when he was And they may get into it may not, well, maybe we may get the same pushback from the POA that we got from the chief, but the ordinance requires it. And otherwise, how would we know that we're getting all the internal investigations if they're not required to tell us that they have, that they're working on an internal investigation? How do we know that they've actually received an internal complaint and they're investigating it?
Mhm.
So, yeah, I agree. I guess I'm just pointing out that we may, this may be one of the things that media confer has an
Maybe
impasse on.
clarifies, or at
Yeah,
least
maybe
maybe there will be
clarifies, yeah.
some, yeah, because
Yeah.
at this point, it's been only conversations between the chief. So at that point, maybe it will be when it will be clarified finally.
We'll see, and another several things we've done with these, even though the media confer is not with the police department, it's because they're part of the city, it's with the POA. But if the city council approves these policies, that makes the policies binding on the police department. So if we put things in here that spell out an obligation of the department and the city council approves it, then they have to comply with the city council.
Okay, so we are down to the last section before we get
Which makes
to.
me
Mhm.
parenthetically
Oh, sorry,
raise a
Doug.
parenthetically raise a question of whether or not the police department will be at the meet and confer. Because when we did the meet and confer regarding the review of the expired cases,
Mhm.
The police department was there. And but I don't recall if they were there when we got the approval of the interim standard operating procedures. I don't recall. We can ask that question, but it's a good question to know of whether or not the PD is going to be there when we do the meet and confer. But the meet and confer is not with them, even though they might like for it to be, but it's with the POA.
So when you say be there, you mean the chief or a representative of the chief and the department itself, as opposed to the police officers association, which of course is the union?
Right. Yeah, I mean be there, because they were there when we did that previous meet and confer regarding the our plan to do the audit of the expired cases.
So there would be the POA, the city people who actually do the meet and confer, and the police department would be in the room negotiating the document.
Yeah, I'm not sure that they would be negotiating, but they would be present in the room. And the way,
Sorry.
yeah, and
Right,
often
Megan?
what they will do when they're because the negotiation is done with the negotiator and the POA person, but if there's an issue that arises, what they will do is they will call a caucus, and then they will get the affected people, i.e. the commission officers, together, and they get our opinion, and then they go back to negotiation. And they may need to, and if there's something that relates to the department, they may want to get the department's input as well. But Danelle?
Oh, okay.
The department, SDPD, does
Right.
have a labor relations section under an assistant chief and a liaison that keeps close track. If they're in the room or not, they absolutely stay in touch with the meet and confer process.
So is the police department of the city of San Diego there as a representative of the city of San Diego, or are the police or are members of the police department there as members and representatives of the POA?
Yes.
It sounds like a conflict of interest.
I don't think it's the POA. I think that they're there as a resource for the city.
That's interesting to have them in the room at the same time.
The command staff would be responsible for the implementation. And
So then every union would do that. My wife is with Park and Rec, so she's represented by MEA, and MEA, when they negotiate with the city, there would be top level brass from the city, from Park and Rec would also be in the room during those negotiations. Is that correct?
not as a negotiator, as a go-to to
As-
ask for
right.
information, as a
Right.
listener, as a just
For the same
be-
reason the police department would be there.
Right.
Same reason the chief would be there. Okay. I can see that. That would kind of make sense. Okay.
Okay. So now back to the policy. Anything else that we,
Yeah, so there was the last section that we had some questions about, but before this, I think we missed Doug's comment on the withdrawal of complaints paragraph. I think that Doug had a question.
About
The
whether
effect,
the vote required.
yeah, I'm just reading what the vote would be required for. I don't know, further investigation, the investigator continue. And commission in its discretion concurs. The effect of such withdrawal will normally be to terminate any further investigation of complaint of conduct.
Okay.
I'm just trying to remember what was in the investigations procedure, because that may be part of the summarily dismissal piece. Share drive.
Oh, so much stuff.
You know, I think the ordinance actually prohibits the commission from investigating.
yeah, if the complainant doesn't want to have it investigated, then we
Yeah,
can't.
so. Perhaps this will just be. Then that none of these two sentences would apply then. It would just be a complaint may be withdrawn from further consideration at any time by written notice of withdrawal, signed and dated by the complainant. Submitted, maybe we can clarify, submitted to the Office of the Commission on Police Practices. And I don't know, then the other two sentences wouldn't really apply if
Yeah,
we
I don't-
can't do any investigations once the
Yeah,
complainant
and
requests.
I think the ordinance is pretty
Mhm.
explicit on that, so I would take that out.
Would you like to add any clarity on how the
Claimant
withdrawal
withdrawn
form needs to be
Anytime, right?
submitted?
Written notice, signed and dated by the complainant. I think that's explicit enough.
Okay. Commissioner Honoré, any thoughts on this one?
Just looking at the investigative procedures, final draft, number 5, no finding, et cetera, et cetera, et cetera. Or is necessary to conduct the investigation or where the complainant or impacted party withdrew the complaint.
Yeah, so it is consistent with the ordinance, right?
I'm just going back to that conversation we had about complainants and impacted parties. And that we had a discussion where we said
Mhm.
that it may be appropriate for us to continue, as it says here, appropriate for us to continue our investigation, even if somebody in the midst of the program decides they don't want to continue their own complaint.
Right, and I think we discussed that with Mr. Bennett, and he said that basically as long as there is at least one person who wants to investigate, we should be
Right.
fine. I think the issue is if it's like one person, they filed, they withdraw, then we shouldn't be able to, we should not investigate, but if there are multiple people and we have people who want to participate in this investigation, I think that's when we're okay, if I recall Mr. Bennett's explanation correctly.
Yeah, I think
Then the withdrawal of complaint section probably should have something that specifically states, and whether it's a document that they sign, that specifically states they do not want us to continue our investigation. It can't be vague, because just because they withdraw the complaint is not necessarily a statement, I don't want it investigated,
Mhm.
right? So, I mean,
why wouldn't it be? That would be, if you withdraw a complaint, it means you don't want the formal investigation.
well, it means you don't want to be involved and engaged in a formal investigation. Maybe there's a cop out there who's on your kid, who's on the list of gang members, and he's never done anything, but this cop harasses your kid, and so you withdraw your complaint because you don't want to be harassed, but it doesn't mean you don't want it actually investigated. But at least you can say, dude, I had nothing to do with it. So whatever's happening with you is, you leave my son alone because it got nothing to do with me. So that should be, I just need to say it, I'm just suggesting it should be stated explicitly in their withdrawal of complaint. They do not want it investigated. It should not just be assumed that because they withdrew their complaint that they
Okay,
didn't want to investigate.
Okay, withdrawn for further consideration, written notice, withdrawal, signed by the complainant, they may be indicating that they do not want a formal investigation, indicating that they do not want to proceed with a formal investigation. But I also think that we ought to maybe state, and I'm thinking aloud here, so don't copy this down yet, but however, if there is more than one complainant on a incident, and one of the complainants withdraws, it doesn't mean that the investigation ends.
Right.
And so maybe something along the lines, unless there is another complainant who does desire a formal investigation.
And
Mhm.
the next slide suggests that we can continue our investigation anyway if we vote on it.
But
I'm
we
sorry, say
can't,
that again?
We haven't put the vote part in yet, but the other next line says the effective such withdrawal would normally be to determine any further investigation of the complaint of kind, unless the ED chief investigator or commission member recommends that the investigation continue, and the commission, and then we're going to get to the vote part, at its discretion concurs.
yeah, but we can't vote on that. In other words,
I think this would need to be removed from this procedure.
because if the complainant doesn't want a formal investigation, we can't vote on whether to do it, because the ordinance is very explicit. We cannot do an investigation if the we can't, and the police department can't do an investigation if the complainant doesn't want a formal investigation. What I'm suggesting is that maybe, however, if there is more than one, if another complainant
Does not withdraw.
does not withdraw,
Right.
if there is an additional complainant who does not withdraw the complaint, then the investigation can proceed. That makes sense.
It
Mhm.
makes sense. It's an interesting, it'll be interesting when we actually come across this. If and when we actually come across this. Where we have more than one complainant, one wants the investigation not to go forward and the other one does.
But see, I could see that happening if you have a third party complaint.
Mm-hmm.
And so you have somebody who makes a complaint, a third party complaint, and the impacted party doesn't want a formal investigation, but the complainant does. Under the ordinance, we would be allowed to do that. We would be allowed to proceed with the investigation, because the complainant, we're only prohibited if the complainant says, I do not want a formal investigation.
Yep.
There is there's no reference in the implementation ordinance to impacted party. That's something that we came up with because the city attorney's office didn't think about that scenario.
So, and in my practice in New York City, that was a very common occurrence. So it can happen and will happen pretty often. And it did again happen with mostly just multiple people, like let's say multiple family members involved, and one said they didn't want to participate. We just didn't get their statement, but we still proceeded with the investigation. So would that language be accurate, description of what Doug you're suggesting?
Well, what if the impacted party did not complain?
Does that matter who the impacted party is and with respect to filing a complaint and its continuance or non-continuance?
No, but so I'd we even say, maybe even take out the impacted parties. And so if there are
Yeah.
multiple complainants
Right.
and one or more do not withdraw, the commission may proceed with an investigation, because it could be that the complainant wants to proceed, but the impacted party does not.
Right. Yeah, I agree. That probably should be taken out because only time we can come in, only time we get engaged is if there's a complainant. The impacted party doesn't file a complaint, we don't get involved. And if they file a complaint, they're a complainant. So we don't have to use the term impacted party.
This was actually, I was thinking for a reverse scenario, again, that Doug just described, the complainant files a complaint. Let's say husband and wife, I don't know, they were both parties to the incident, just the husband files a complaint. He
Mhm.
withdraws, but an investigator reaches out to the wife and she's interested in moving forward with the complaint. So she's not a complainant, but she's an impacted party.
Right, but with respect to the complaint process and quote unquote withdrawal of complaint, until she actually files a complaint, she's just another person out there, right?
Yeah, so you could say if there are multiple complainants and impacted parties exist, and they do not, and they wish, well,
If you have a complainant and an impacted party, even if the husband complains, the wife does not. The husband withdraws a complaint. How do we go forward? We don't have a complainant anymore.
We don't have a complainant, but if we speak to the wife and she agrees to participate in the investigation and signs the interview form, she's interviewed, then we should be good.
Does she become a complainant?
Not necessarily, but she will
But
be an
that kind of, but see,
impacted
that kind of
party.
contradicts what we're saying here, because if we have a complainant, the complainant withdraws and says, I do not want this investigated. And then we go out and find another complainant and they don't actually complain, they don't file a complaint. How do we continue our our process, even if it's not a quote unquote investigation? But yeah, how do we proceed? We don't have a complainant. And the one that did complain withdrew and said they didn't want any follow-up.
yeah, I think Globus is right. We need to have a complainant who wants to proceed. So we could ask the impacted party if they want to become a complainant, if they want,
Mhm.
but so I would just
Okay.
take out an impacted parties,
Mhm.
Yeah.
Okay.
and they exist, and one or
We
more.
can still do that, Olga. We can always
Okay, exist, yeah,
talk to them
okay.
and say if they want to file a complaint, but they would have to file the complaint for us to follow up. That's
Yeah,
part of
that makes
the career
sense.
process,
Okay.
right?
Does that sound about right?
Mhm.
Okay, so and then we are removing these sentences then.
Right.
Okay. So the last piece was the notification to parties, and I think we left off in the previous meeting, we were discussing, should there be a time frame? When the commission will notify a complainant? When the complaint is filed about the classification of the complaint, and we left off as to whether it should be any particular number of days, 10, 14. I think that was our conversation.
Well, if it's
And
10
the
days, then-
issues here is that we need to move swiftly because the SOL and everything like that. I think that was also part of the conversation. The SOL kicks in as soon as the commission receives the
Mhm.
complaint, so.
Well, do we have to notify them? I agree with within 10 days, we'll notify by telephone. Wait a second, within 10 business days of the receipt of the complaint, the commission will notify a complainant or affected party.
When does the police department notify people of its processes on complaints?
I'm not sure of their process of notification, to be honest.
Do we need to let them know the classification at that initial?
And I think that's up to you to decide whether you wanted one notification, whether you wanted first just a deadline for commission to acknowledge it received the complaint, and then maybe another deadline to provide a classification. I think it's good to have some benchmarks. But again, just my thoughts on this. Just knowing that if the commission were to initiate an investigation, according to the investigations procedure, it first would need to go through the executive director, the chief investigator would advise the cabinet, and then the cabinet would make a determination whether to initiate an investigation. So that may take a while, right?
Mhm.
I
So
think
what exactly do you mean by classification?
So classification of complaint, whether it's a complaint that goes to the police department or whether this is a
Okay.
complaint that will be accepted by the commission for an investigation.
How about if we just say, and the status of the complaint?
Sure.
Where is
Because
that
I
gonna go?
Well, that has received the complaint and its status.
And its
That's-
As opposed
status,
to
yeah.
classification? Okay.
Yeah, because when I saw classification, I was thinking of classified as Cat 1, Cat 2, which is,
Yeah. Mhm.
or formal, informal, or whatever. And so, and so you, yeah, and its status.
And that would potentially either be commission is still reviewing and deciding, right? So
Mhm.
or your complaint was forwarded to the police department. So just to clarify, do you want another benchmark when the commission would need to decide that it accepts the case for investigation or not, or you would not want to limit yourself to any specific date, knowing that it may take a while for some of these cases?
I would prefer not to limit us, because if you put it in writing and it's a requirement, then you get in trouble if you can't do it.
And I would go back and ask again, does the police department have such limits, such time frames?
I don't think so.
I have
Yeah.
not seen it anywhere in any of the procedures that we've come across. So like the citizen complaint, again, they may have their internal maybe manuals or benchmarks, but I've not seen that as well also in any sort of general procedure.
Yeah, I think in
But
the case of the department, the only communication that they receive is, we received your complaint. And of course, presumably they will be contacted when they're doing the investigation. But then they're notified at the result, but they're not notified of, anything else along the lines.
Mm. But knowing that there's a 1 year limit on on this complaint, there's got to be some kind of internal time frame for them to do some things, right? We can't go 360 days and then say, oh, and then say, well, we got 5 days before the thing expires, so now we got to do something. I'm sure that I'm sure the legal representatives will let them know that there is going to be some liability if there is not some kind of time frame, some responsible time frame for some kind of action on the part of the police department. Considering there's a statute of limitations on
Right.
the investigation, so there has to be something on their side. But if we don't know what it is, then we can make our own.
Right.
I am concerned, and I don't know.
But what we are doing is we're going above that, and I'm not even sure the department does this. We're telling them who's in charge of the investigation and the complaint number. So we're giving them the ability, if they want to follow up and say, what is the status?
Okay.
They have
Yeah.
the ability to do that, which I don't think the department does that. I don't think the department gives them a complaint
Probably
number, or gives them a name and phone number of the person who is doing it. I'm pretty sure they don't. They just wait until the person calls them.
I do have a concern of the use of the term impacted party in this section. Notification to parties. If I am not the complainant, what access do I have to the information that is being contemplated in this complaint?
And I think you're making a good observation. So perhaps at that initial notification, it may not be appropriate to notify the impacted party, but once they become part of the investigation, I think they would be entitled to checking the status of their complaint and the outcome of the complaint. But
I'm
maybe
still
not
concerned that only,
here.
for confidentiality reasons, I'm concerned that only the complainant would be the person we would be able to divulge certain information to. They're the only one who signed certain documentation, attesting to the veracity of the information. And this is confidential stuff, right? So I don't think the impacted party should be part of who gets notified about stuff.
So
If they want to be
it's
notified, they
actually-
need to file a complaint.
So it is actually within the commission's purview now to codify these things and determine how much you want to divulge to the complainant and impacted party. And then impacted party, many of the times they are people who actually experience the conduct. And this is more for those third-party complaints, right? So once the person becomes an impacted party, an investigator will reach out to them and interview them. At the end of the interview, they will sign a form attesting that all the statements they provided are true to their knowledge. If you remember that appendix in the investigations procedure.
Okay.
So now they are officially part of the investigation. They have, I would say, the same weight. They should have the same weight as a complainant. We are introducing this term because, again, to give them those rights. Because technically, if you think about it, if we have those third-party complaints and the people who actually experience the conduct, they're not entitled to any notification. This is actually to do the opposite and to make sure the people who experience the conduct do get those notifications and updates on the investigations and the final letters. And they will have the same weight as the complainant, but witnesses will never have the same weight as the complainant or impacted party. Witnesses would not need to be entitled to any of these things. So I would say this is actually a better and good provision to allow the commission to treat those people equally to the complainants in those circumstances.
And you're saying that it is within our purview to make that determination.
It's not mentioned anywhere. It's just, yep, I think it's within your purview now as you're drafting these procedures to codify this term, because unfortunately it was never thought of as the
Right.
ordinance was being passed. And
Okay.
that's, I think, a big oversight.
Okay, well, again, if it's within our purview and if those impacted parties are considered within their legal rights to have the information, then I think it's great to have it in there.
And again, they will also sign forms. So it will only if they are interviewed, they go through the full process, they sign the form that they tested, what they said is true to their knowledge, then that would be, we would have technically their written complaint, basically. It won't be the initial complaint, but it will be their interview with the signed attestation form.
Yeah, I'm still a little skeptical. I like having it in there. I like the idea that you are elevating the impacted party to the level of the term you used. I can't remember right now of the complainant. But I'm going to tell you, I'm still a little skeptical that someone who has not filed a complaint in a process that is highly confidential, right? That person is going to have access to information, although they have not actually gone through a particular process. But if we can get it done and it's within our purview to put it in here this way, I think it's worth looking at. I'm just wondering what kind of response we'll get from all over the place. But I like it.
Do you have any thoughts on this? And I know we are over our time, so.
Oh, okay.
Okay. I agree with Clovis. I think I think we should keep it in, and if we get pushback, we can consider.
Negotiating point.
Oh, and actually, I just realized that Commissioner Harvey has been part of this entire meeting, and
Oh, man.
he just typed in the chat, the
Where is he?
complainant is the only controlling party. But I have not
I don't see him on
seen
my.
Wow, he's an attendee. Okay, he didn't come in as a
Okay.
panelist.
We
You
can
can't see
promote him
him.
as a panelist. I didn't know he was.
I just did. I also did not realize he was part of this meeting.
Okay. So
Olga, can you promote him from
Yeah.
participant
Yep,
to?
there it is.
Yeah, please,
Just-
please do
just-
that. Good.
I just did that,
What-
yeah, it doesn't
Oh.
seem like it's working,
Thank you.
but I just did that
No,
several
I see
times.
I see him in his hand.
Um,
Is up.
Okay, well, Dwayne lowered his hand. Dwayne, we apologize. We didn't know that you were there. So,
Yeah, I had no way of letting you guys know because when I got on, this is the only way I could get on, and so I didn't let you guys. I'm watching, but I couldn't
yeah.
let you know it was on.
yeah, so
Um,
if you
next
click on
time,
the,
yeah,
know,
please
if you
flag
click
this
on the
first.
link, if you click on the link in the email that Alina sends out, for the,
I did. I tried to do everything. I tried it all. I couldn't get in.
okay. I had some problem too. It wouldn't let me initially, but I got in.
Yeah, and I've seen that before. At a certain point, they'll just lock you out from being a panelist.
Now, if
And
you
yeah,
raise
and-
your hand, do we see the raised hand?
I raised my hand and then I tried to get on the chat and then the chat was disabled. So then I just got on the question and answer. I just find, well, let me try the question and answer. So I just got in on that. Yeah.
Okay,
Okay, well, we apologize for.
It's not a problem. Not a
But I think
problem.
Commissioner Harvey is raising the point that I was trying to make.
and Commissioner Harvey, would you like to expand on what you wrote?
Yeah, I think what we probably need to do is educate because it would seem that if we reach out to individuals, then I think when we were in our CPP meeting, I think our concerns were commissioners actually being involved and actually aiding individuals in filing their complaints. And to me, that kind of seems that way. If we're going to speak to someone and telling them that, hey, you guys, if you want this to continue, you need to file a complaint. And, maybe, I don't know if we'll be overstepping our bounds in that. I think if at the beginning, when who's ever filling out their paperwork, maybe there needs to be something where you can talk about, where they can file, there could be multiple complainants because it seems that there's either a third party complaint or just one other complainant. But impacted parties, all of them can actually be complainants.
Yeah, well, and that's why we put up there that there may be multiple complainants.
Yeah, but if there are multiple complainants, is one thing. But if they're not, then honestly, they're just out of luck. If they're not, if the complainant is the controlling party, meaning that person can either say, let's have this complaint, or I don't want the complaint. If the other individuals aren't complainants, then they may be out of luck if we can't really pursue.
You're right, and that's what we did, and so that's the language we came up with was that it's in the previous paragraph. It says, no, I think don't scroll down. You were at the right place. It just previous, yeah. A complainant may be withdrawn from further consideration anytime by a written notice of withdrawal signed and dated by the complainant, indicating they do not wish to proceed with an investigation. In cases where there are multiple complainants exist,
Exactly.
one or more do not withdraw, the commission may proceed. Yeah, so we agree with you.
Yeah, that's not. Yeah, so you took out the impacted parties then.
Yes, we did.
Yeah. Okay, that's fine. I think that sounds good. But when
so now what we're talking about is a notification,
Right.
and we're saying that should we notify the impacted party when a complaint has been filed
Or withdrawn in this case.
So I
Well,
think
I'm sorry, let me
this
back
one
up.
has
Yeah.
to do with the first
Yeah.
one, the complaint is
Yeah,
received.
notification. Yeah. So we're dealing with
impact. Okay, I'm sorry. Yeah, the impacted parties. If I honestly don't see why any of the impacted parties shouldn't be part of being notified or being part of the fact that this is an ongoing investigation. We ought to be able to tell them what we can tell them if they're impacted parties. The thing about impacted parties is, how do we know at what level does an individual become the impacted party? I mean, I can say I'm on the outside just looking at it and I'm traumatized. Am I an impacted party?
And Commissioner
right.
Harvey, this is a great point, and I think there needs to be some clarification on who
Yeah.
actually the impacted party is, and
Mhm.
we did
Didn't we do-
introduce that in the investigations procedure. And it says impacted party is a person directly affected by at least one or more allegations or
Mhm.
instances of police misconduct. So again, it is actually a person who experienced the conduct from the
Okay.
officer.
But I think those individuals should be informed.
Can we,
We inform them or give them, I think we should be able to.
Olga, can we put that same footnote in
Sure.
the complaint procedure? Because
Yes.
people may not refer back and forth, so maybe the first time we use the term impacted party,
Mhm.
put the definition at the bottom.
Mhm.
Yeah.
Yeah.
that's what I do.
And I think that's where maybe the confusion is stemming from, is the who actually is the impacted party. And again, I think we are grappling with the fact that unfortunately the ordinance is imperfect, and it says a complainant is a person who files a complaint. But again, it's usually, and maybe 5 people who were stopped in the car. They don't need to each individually go and file a complaint. One of them can file a complaint, and all the other 4 are automatically impacted party because they were part of the incident. And that's specifically to ensure that they have the same rights as the complainant.
But is that worded that way, that impacted parties have they're at the same level as a complainant? Because if a complainant says, no, I don't want it, an
Right.
impacted person never says I do or I don't.
Well,
But-
if they don't say, well, the ordinance says that only if the complainant doesn't want
Yeah.
it done, then if the impacted party is not agreed to be a complainant, then they
Yeah.
don't have the right
They don't have
to
that right. They don't have that right. Yeah.
yeah. So, okay, so to go back to where we were then, Olga, for the notification,
So we probably want to remove the impacted party at the initial notification because they didn't file the complaint, if I heard you correctly. Right? Because this just has to do about the receipt of the complaint and its status. So frankly, at that stage, the impacted party may not even be aware of the complaint
I
filed
agree.
yet.
But yeah, so I would take that out, but we did keep it in the next paragraph where we said that the
Mhm. So then we say that they may, that the commission must identify the staff and provide their information to the complainant and or impacted party.
Mm.
And then the complaint, impacted party or subject officer may check on the status of the case at any time. However, the commission must provide a notice to complainants on the status of their investigations no less than every 45 days. And I suggest we may want to include impacted parties here as well.
I'm saying if we can, I would say fine, but if we get pushback on that, because again, they don't control it.
yeah, so I agree with Dwayne. If I would put it there, if we get pushback, we can remove
My
it.
battery's down. I'll be right back. I think I have a different down here. Do I have it down here? I do.
And you're down to the last 2 paragraphs.
And a word to the wise, when you plug in your computer, remember to turn the power strip on. Can't tell you how many times I plugged in the computer and it died anyways. What the? I'm like, oh crap. Okay, I'm good.
Okay, yeah, so that looks good.
And then here we actually specify that third-party complainants, maybe we can specify who were not party to the incident shall not be provided with confidential information, or just simply will not be provided with confidential information.
Yeah, but do we need to even third-party complainants? What's wrong with the way that it's worded?
No, nothing wrong. I just realized that nothing wrong with that. As I said that.
Okay, and so we are over time. Was that the last one?
Yeah,
Okay, then if you can clean it up, and then I will send it to our outside counsel for him to look at before we present it to the commission. And if he has any concerns, we can discuss it at our next meeting. Clovis, did you get a chance to look at the subpoena and Pitch's motion?
I read the Pitch's motions before. I did take another look at the subpoena one, but I still have a concern here on this last line where a third-party complaint is not investigated because the impacted party does not choose to file a complaint.
Go back to the, if you could put it back up, Olga.
So this contradicts some of our previous language.
I don't
Someone
think
files a
so.
complaint.
The party
You follow
complaint
up.
is not investigated because the impacted party does not choose to file a complaint.
Right? All the conversation we just had was we have somebody who files a complaint who may not be an impacted party. And we
Complaint.
have all this verbiage and conversation we just had about the impacted party. Now we're going to say if the impacted party does not file a complaint, we won't we will not.
That's a good point. Maybe do we even need to include that? Because
That needs to come out because that contradicts what we just said. Right?
okay. I
Um,
think it could be, I think it was supposed to say when a third party complaint is not investigated because the impacted party does not choose to go through with an investigation. The third party complainant should be notified as such. I think that was the original verbiage, but so basically that exists to ensure that whoever files the complaint, even if they're an observer of the incident, they'll at least know that there was no investigation into their complaint because the commission was not able, let's say, to interview people, or none of the impacted parties wanted to go through with it.
but we
So-
can but we would normally do that anyway. So say that
yeah.
I mean,
Yeah,
we're gonna let them know that the outcome of the investigation, and if the
that's true.
investigation is that we weren't able to well, we dismissed it because the impacted party wasn't willing to talk to
Yeah.
us, you know, then that would be what the outcome was. We don't need to put that there.
Yeah,
Okay,
because my concern is that, as Commissioner Harvey just said, the complainant controls the process.
Yes, that's a
That
good
we haven't
catch.
described so far up to this point. And so if a complainant, even if the third party files a complaint and the impacted party chooses not to cooperate, that is not a cause for us to automatically drop the complaint. That is after we go through the investigation procedure, we make a choice not to further investigate, but we wouldn't be just because they didn't file a complaint. Because they didn't cooperate, we weren't able to gather enough information to actually follow through, but not because the impacted party didn't file a complaint.
So good catch. That's
Did you want to delete that or strike that?
I deleted it. Because it's already in suggestion mode, this entire paragraph, once you delete something, it just permanently deletes it. If you see, it's actually all in green, so it's deleted.
Okay. All right, sorry, we were moving on to.
Okay, so at the next meeting, well, why don't we put the subpoena and Pitch's motions on the agenda for the next meeting, and hopefully it won't require a lot of discussion. If it does, that's fine. I personally think that it's just a reiteration of legal processes that Dwayne has outlined, and that we don't really have the ability to contradict. But we'll put it there because we need to approve it before it goes to the commission, and then we can hopefully spend the bulk of our time in 2 weeks looking at the case review. I forget what it's titled, but it's a review and evaluation of IA investigations and misconduct, whatever. It's whatever it's
Review,
called.
required review internal affairs investigations of police officer misconduct. Is that the one?
Yes,
Yes.
and it should say updated at the on the name of the document.
Okay, okay, yeah.
Okay, and so that's what we're going to do next time. I'm finished with that. I mean, it doesn't mean we can't make changes, but I finished. It's ready to be vetted. So, and so then we will offline figure out what we're going to do about the records policy, which Tanel has agreed to take off of our hands, but we need to figure out what we're going to do about the review and evaluation of SDPD policies. I mean, SDPD compliance, and we can talk about that offline too, but we need to put that in we need to get that in our packet of stuff that goes to the meeting confer. And our goal is to get all this through our committee by the end of May so that it can get through the commission by the end of June.
And if I could add, one of the things that I've been sketching out is the how they're all integrated as a document to send forward. That's the advice that we got from labor negotiators, is that we're not sending individual standalone procedures, but they're integrated. And so that's also something I feel like staff can start, is that shell, that framework that will be the container for all of these procedures. When you look at them, they will be the big section heads. And anyway, just wanted to add that we'll begin creating that framework. That's the
Wait,
advice we got.
When it could be a one-page summary of what they are with the table of contents, and then
Table of contents, absolutely.
Okay, well, we are. So have you enjoyed this thoroughly, Danelle? I wish you've been to all of our previous ones.
What I have heard is the intentionality and the deliberation that you're going through this. It actually increases my comfort level in standing up and saying these are ready. So thank you.
So, okay, everybody,
then.
we'll see you at our meeting next week. And I guess that's it.
All right.
We'll see y'all on
Have a good
Wednesday
night,
at
everyone.
9:04.
Okay, good night.
All right.
night.
See you.